Thank you so much, sir, for joining us. We are honored to have you here on this episode of Legal Talks at Intellex Juris. We are elated to have you here to share insights into labor law advocacy. For our listeners, we would like to share that Bipul Kumar Mishra, sir, has around 25 years of rich experience in labor and service law and commercial laws in Delhi High Court and consumer dispute cases and conducting domestic inquiries. Now we have got Sakshi Priya joining us to start the conversation.
Thank you, Bhamini. First of all, thank you, sir, for accepting our invitation for this conversation on labor law advocacy. There are a very few people who help the aspiring lawyers to decide their domain of advocacy. So we really wish that this initiative by us will help the listeners to decode their interest in labor law advocacy. So, sir, first of all, we would like to understand your overview on labor law cases and what are the range of issues that you require to deal with in this domain.
Thank you, Sakshi. I'm pleased to have this podcast meeting. I'm thankful to your team as well.
Thank you, sir.
See, labor law legislation is altogether different from civil jurisprudence or criminal jurisprudence. It's altogether different. In this, initiation of case starts with a number of forums. Like first, it starts from conciliation proceeding before a conciliation officer. Then after conciliation, it is being referred to the labor court. After labor court's decision, either party can file a writ petition, only and only a writ petition. So this question may arise, why writ petition? Why not appeal and all anything else? So in this, what happens that cases since being referred by appropriate government, those are the labor office, you may say ALC or conciliation officer. Since it has been referred for an answer to the question of terms of reference, what should be the terms of reference? Like I will give you an example that if a workman has been terminated, so terms of reference would be whether termination of the workman is illegal. If so, what reliefs can be given? So labor court answers that reference. So this is a question between government body and between court. Hence, since the initiation of the matter is from a government body, so anything with challenging the government body's order will lie into a writ. So it is a writ. Thereafter, it goes to Supreme Court. So this is the way how we proceed with labor cases. Now, initiation of labor cases starts from section 10. It also starts from section 33. The question is now it starts from other forum also, like if there is a general demand of number of people, number of workmen employed in an organization. So if general demand case is pending, and meanwhile, if some misconduct is being done by an employee during pendency of that general demand case, we need to take permission from the labor court to terminate him. So this is called permission. This is OA. And LIR was from the earlier I described you that it starts from section 10. So there are a number of forums, a number of ways by which a case starts. Now, third is under 33C, if an admitted claim of a workman is there, so he can go directly to labor court saying that these are my demands, which were promised by a management, but yet it has not been fulfilled. Hence, I have come before the court for resolution of my disputes. So these are the way how labor cases starts. I hope I'm clear on this and you must have understood the way.
Yes, sir. But sir, there are a lot of misconceptions related to labor law, and maybe that's one of the reasons why this is a domain least touched by a lot of advocates. So, what are the misconceptions you feel are present in the mind of advocates?
So first of all, I would say that if I'm dealing cases on behalf of the management, I have dealt very few cases of a workman.
Hmm.
So when we deal with the management, suppose if management says that I don't want this employee for any reason, he has done a misconduct or done anything, what the management will do, it will put allegations on him. He will issue a charge sheet, a show cause notice. He will have to do a domestic inquiry. After domestic inquiry, again a show cause notice has to be issued to a workman. Then he will be terminated from the service. So,
Hmm.
being a management lawyer, it's very difficult to make understand the management that how to proceed with, because management always remains in a haste. They want no. I don't want this person from tomorrow. Do whatever you want to do and whatever ways
Hmm.
you have to find out. But we have to go legally. So all these things, and the most important thing is labor law is, although ID Act is there, although Factories Act is there, payment of wages are there, every act is there, but still it is considered to be an uncodified law. Why
Yes.
it is considered to be an uncodified law? There is no provision in ID Act how to conduct a domestic inquiry.
Hmm.
It is completely based on principle of natural justice,
Okay.
odd altrum partem, and all.
Hmm.
So it is totally based on the precedents of Supreme Court and other high courts and the judgments. So we have first and foremost thing, we don't find anything in the book. We have to read the judgment. We have to read the natural justice related books. Only then we can proceed with domestic inquiry properly. Otherwise, if a domestic inquiry is initiated before court of law, then what happens? Then your entire exercise is gone.
Hmm.
So this is such a thing. It is not, see, it's a welfare legislation. So being a welfare legislation, a lawyer has to keep in mind that how to deal with it so that any action of the management does not go in vain. It should be properly handled. So this is a biggest hurdle for which experience, expertise, everything is required. That's why people don't tend to go in this field. Even in
Hmm.
my college days, even in my college days, when I was studying labor law, it was the least of my interest. I was studying this only for getting pass marks only. I had no interest in this. Only after doing practice in civil law for a year, then criminal law another year, 2 3 years passed.
Hmm.
Then I met a senior who was uh, stalwart in this field. So
Hmm.
first question arose in my mind, sir, I don't understand this ID Act. I'm failed to understand where the case is initiating from. So he told me
Yes,
to
sir.
read this section and this section. And then after
Hmm.
45 minutes, he asked me to come. And then he explained me the way how it proceeds. And another aspect of this is that strictly Evidence Act is not applicable over here.
Hmm.
Strictly CPC is also not applicable over here.
Yes, sir.
A claim can be filed without supporting affidavit.
Hmm. Not the misconceptions. Actually, these are the reality checks, and that's the only reason why people don't opt for this domain.
Yes, I would like to I'd like to share you with the theory of white man's burden theory.
Hmm.
Public administration in the East, you will find a theory that's called white man's burden theory. What happens into this? Itself inferior than that of people of Western origin.
Exactly,
If a
sir.
person from
Exactly.
US, we find inferior. So this is white man burden. They are
White
white
man
in nature,
burden.
so that's why. So white man's burden. So even happens here also. We
Hmm.
consider ये तो labor है. देख लेंगे.
Hmm. Hmm. Hmm.
So even then they are laborers, they are workmen, they are poor person. Don't they have the right? So
Exactly,
the
sir.
management considers the same thing that ठीक है, we will see to it. So nobody takes it very seriously.
Yes, sir. Thank you so much, sir, for letting us know the actual reality of the labor law cases. But, sir, we will be very interested to know if any of the high profile cases that you have dealt with and what were the key challenges related to that case.
See, every case is a challenge for me.
Okay, sir.
So I can't say this was a very. Yes, few cases were there. Like in
Mm-hmm.
one case, it was of an organization. I would name it. The organization was Siram Research Institute for Industrial Research. Siram
Okay, sir.
Institute for Industrial Research. And the workman claimed himself to be a workman, although I resisted on it that no, I objected to it.
Okay, sir.
He was a
Okay, sir.
scientist. He was a
Oh.
scientist
Mm-hmm.
and he filed the case before labor court. I contested the case right from the conciliation officer till labor court.
Oh,
And
okay,
a
sir.
very renowned lawyer of Delhi, he was contesting from the side of the workmen. He was brother of a sitting judge also at that point of time. So
Mm.
he was harping it upon that he is working like this, he's working like this. I did the cross examination. In the cross examination, I culled it out from him itself that what was his nature of job.
Hmm.
So he agreed and accepted that he was issuing slips, he was issuing leave, he was signing leave applications, he was using his acumen doing while doing research activities, and he has
Hmm.
done some research works also. Papers have also been published. I took into account all his acts, and I showed up to the court that what were his duties, what were he was doing. He was in charge of a thing also. So, considering all the aspects, Labor Court came to give this decision that no, he was not a workman, he was a scientist, and scientist is not a
Hmm.
workman. So the
Okay, sir.
famous judgment
Hmm.
of uh, Jamia Hamdard University, Divyansh Pandit versus Jamia Hamdard University, it's a very old judgment in which
Hmm.
it has been stated that who scientist is not a workman. I took help of this judgment also in this case.
Yes, sir.
So then his claim was dismissed and a no dispute award was passed. This word no dispute award
Hmm.
is a judgment. It's a
Oh.
judgment. But
Hmm.
in labor law, it is called award.
Award, yes, sir. Hmm.
So this is the difference between common law and labor law.
Labor
So
law
even judgment, the judgment it is called as award.
award. That creates a basic
Yes.
difference between a normal case and a labor case, sir.
I
Sir.
remember one of the case it was in High Court, and in that case, the workman was later on become an advocate,
Hmm.
and he himself was contesting his case before High Court. We had challenged the labor court award before High Court, and he filed an application under Section 17B of IDF. I'll explain what exactly 17B. 17B of Industrial Dispute Act is a provision in which if reinstatement has been awarded to a workman in an establishment, and if the establishment challenges this award before a high court, then in that case, the workman has to be paid subsistence allowance equivalent to his last drawn wages or minimum wages, whichever is higher. So
Okay.
he filed application under Section 17B for
Hmm.
grant of this uh, subsistence allowance. I opposed this, and on the ground that he was after termination, He was working as an advocate. Advocate is considered to be a noble profession. He was charging fee also from his client, and he was filing income tax return also. So in that case, it cannot be said that he was not gainfully employed after termination of his service. So that 17B was application was dismissed, and this case has been reported in a journal also.
Oh, that's a great thing, sir.
Journal also has been reported. So it's a landmark judgment on 17B. These are very, I
Great.
mean,
Hmm.
very intricate things. 17B will not be understood by a person who is not practicing in this field until unless he goes into it deep rooted. This is a very deep
Deep
rooted
rooted
thing.
research. It's a very
Only then he
technical
will be
section.
understood. It's very technical. So this is
Technical.
one of the case.
Great, sir.
One
That
case
was
was
such an interesting case.
one case was against Indian Railways. It was filed by a workman. I was representing the workman in Supreme Court of India.
Yes, sir.
Although I put my case beyond doubt from labor court, someone else was looking after the case. It was from Varanasi. And in Supreme Court, I was dealing this case. Although everything was in my favor, but Supreme Court says that again it will be harassment for the workman if I send it back to the labor court for fresh decision, for giving a fresh decision on it. So the matter was compromised between the parties, and he got a handsome amount in this. So these things are there, and cases used to come in this way only.
Great, sir. So many interesting cases are there, sir, and we are so elated to learn more about it. But, sir, what are some of the essential skills that you feel one should have before entering into legal law, labor law advocacy?
There is no straitjacket formula in labor law. Hence, there is no straitjacket formula for an advocate to enter into this field. Only thing is that
Okay,
there
sir.
should be interest. If you are inculcating your interest into this field or any other field,
Hmm.
you can
Hmm.
be very well versed into that. Only thing is that a lawyer should stick to one golden rule of I quote a Sanskrit slok in this Charaiveti, Charaiveti, Charaiveti. You have to go with the flow of the case because we
Hmm.
we never win a case by by being on a strong footage. Sometimes our case are weak, yet we win the case because of the fault of the other side.
Yes, sir.
So
True,
you
sir.
have to
Very
keep
practically,
your
you explained it.
yeah. So you have to keep your ears and eyes open all the time. Take the advantage
Yes, sir.
and win the case.
Yes, sir. So your guidance and knowledge have definitely provided us so many insights on legal professionalism and also knowledge related to the labor law practice. And we really hope that this conversation will help our listeners who could also be law students or even budding lawyers to shape their career in labor law. So we were very honored, sir, by your valuable presence. We had so many questions to ask you, but we are constrained with time, and we really hope to have another episode with you, wherein we will come up with more of such questions, and you will be guiding us throughout the journey, sir.
Sure, sure. One thing I would like
We,
to add at the end of it that
sure, sir.
I'm also a student. You are also a student. We all are a student. We are learning day by day. So one should
Yes, sir.
remain a student. We are student of law. Law is gradually changing day by day. Every
Exactly.
new aspect you will find in a case,
Mm-hmm.
every new case you will find a new aspect
Yes,
of
sir.
law. We'll have to read the sections time and again.
Hmm.
Why? Because we have to learn out of it. So we, as an advocate, are always a student. We are student. We were student. We are student, and we will be
Always
student
be a
all the
student.
time.
Yes, sir. We are very
Yeah.
honored by your valuable presence, sir. We wish you a wonderful day and a healthy life ahead. Thank you so much, sir.
Thank you. Thank you.